My Lord, Ssemujju Ibrahim. As Lady Justice Kanya found, he is still 52. He's a resident of Kasa village, Chirinya parish, division, and has his national ID and a letter of introduction from his LC. He's also the member of parliament for Chira municipality. He's a close friend of first applicant. Second surety is the Honorable Muhindo Harold Tony. Member of Parliament for Konzo County, Muhindo Harold Tony. Is a member of Parliament for Konzo County East. His age 52. He's also a close friend of the first applicant. He has the LC letter, national ID. Present. The third is the Honorable Mps Wafula Ogutu. Yeah, he's a close friend. The first applicant is a resident of 12 Matters Crescent in Tinda, Salim Bay Road. 12 Matters Crescent in Tinda in Akawa Division. Lord, the three sureties have undertaken to ensure that the first applicant appears as and when required. Have the capacity to ensure their friend, colleague, abides by bail terms if released. Lord, the first two, again, Yolan's sister, Justice Kanya, found that they were able to exert influence over the first applicant, ensure that contains court. Right. So the first applicant himself, one of the most obedient persons who walk the face of this earth. For the second applicant,
till the prosecution discharges its burden of proof. It's therefore misleading and probably deliberately so for Mr. Mbiribumbuka to claim that they will commit, if released on bail, they are likely to commit other offenses. They have not committed any so far, as per the law. They are innocent. And by parity of reasoning, the fact that the prosecution keeps on prosecuting A1 and never concluding in a conviction, we can take it as proof of abuse of the process of the court, deliberate abuse of the process of the court by the prosecution. We urge the court not to be drawn into this web of likely abuse of the process of the court and to admit the accused persons to bail because the court has the discretion to do so. And bail can be applied for multiple times. It's never res judicata. In this particular case, my lord has already been told that there are new reasons. Apart from the stay application, I did indicate that they have now stayed in custody for more than a year, which ought to be frowned upon by the law because justice delayed is justice denied. And I did cite that unless the court admits them to bail, they will be condemned to spend a second Christmas in custody, contrary to the presumption of innocence. I would like, through the court, because I objected and the court asked me to wait to say this later, refer my learned junior, Mr. Biribumbuka, to Article 21 of the Ugandan Constitution on equality and freedom from discrimination. It is not right that he disparages a surety purely on the basis of her gender and status as a wife, because this freedom from discrimination is on all areas, whether it's gender, and it's more articulated in Article 33. One should not be discriminated upon on any basis. The question is she a good enough surety? And I think we demonstrated she is. And generally speaking, A2, like most other people, would not want to put his family on the line. So the wife is a most compelling, as a surety, is a most compelling reason why he would turn up. I don't want to speculate, but I believe that even Mr. Biribumbuka would admit that the role played by both his parents, who are of the opposite genders, or those around him, shows that they're both capable and equal. And therefore, Mrs. Halima Mutale is a good enough surety for her husband, and he is most likely bound to turn up when the surety is a member of his family. And the same for his brother. I'm asking the court not to allow the prosecution to violate the Constitution by introducing discrimination, which is prohibited by the Constitution, and also violating the presumption of innocence by branding the applicants as criminals. I would also like the court to note that we are before you very hopeful that you will grant stay. But in the unlikely event, most unlikely event that you don't, you still can grant bail using your inherent jurisdiction. And I've already indicated the new matters that have arisen. And my colleagues have already submitted on age. So yes, our two prayers are intertwined, but they also can each be viewed separately. My Lord, we urge you to ensure justice is done in this matter, to not only grant stay, but also to grant bail to the applicants and not to allow abuse of the court process. Finally, it was suggested by Biribumbuka that we should have gone to the Constitutional Court, which is the Court of Appeal, for application for stay. And I would like to refer the court to an authority, which I will not read to the court, just give the citation, Nabosa Aisha versus Yagala Christine. Nabosa Aisha versus Yagala Christine and others. Civil Appeal number 31 of 2025. It's also civil application number 26 of this year, where the Supreme Court clearly stated that the court to apply for stay in first is the court which gives the orders. Therefore, we are in the right forum. We could have gone to the Court of Appeal, but the place to start is here. We're in the right forum and the court ought to grant the orders sought.
Birth, justice, so my lord, the law gives the applicants the right to seek those orders, those remedies we are seeking. Not only in this application, but all the applications that we have filed, you made reference to, including bail applications that we have filed before. They have not been frivolous of excessiveness. Really, my lord, the argument that Onyango Bo and Mwenda decision is inapplicable here. I wouldn't expect that, my lord, from Mr. Birivumbuka. This is a locus classicus on matters of stay of proceedings. And my lord, for the record, I would refer you to Article 132, Clause 4 of the Constitution. 132, Clause 4. The Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so. And all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. My lord, this honorable court is bound to follow the Onyango board decision pursuant to this provision of the Constitution. You are bound. Indeed, my lord, this court is bound to disregard all these other authorities Mr. Birivumbuka cited and put into, follow the one of Onyango and others. My lord, this has been the decision in the matter of Ssemujju and others. Versus Attorney General, Supreme Court, Civil Appeal, no, Supreme Court, yes, number 1 of 2002. Constitutional Appeal, rather, not number 1 of 2002. The lead judgment by Justice Odoki CJ as he then was. The principles are laid down there. And my lord, if you follow that decision of Ssemujju and others, the authority of Yoweri Kaguta Museveni versus Daily Monitor will fall by the wayside because it was decided by incurium. It was decided by incurium. And a couple of other authorities, my lord, which I may not cite here. The second last issue, my lord, the uniqueness of the bail application before you. It's not the ordinary bail application. Not the one provided for in section 14 of the TIA. Yes, but my lord, this one is reinforced by other provisions. Earlier on, my lord, we cited section 143 of the Judicature Act. No, section 43 rather, formerly 39, and then section 14 of the Judicature Act, which do not ordinarily apply in these other bail applications. But in this particular case, they are the basis for the decision we make. And this brings me to the issue of the applicability of the Ssemujju decision of 2016, which my learned friend here, Mr. Birivumbuka, indicated would be premature to cite it now at this stage. That left me puzzled, my lord. There are two strands to the application, two orders we are seeking. Stay of the proceedings and then release. And they are conjoined. They have to be argued concurrently. I failed to make head and tail out of his submission that we first wait for the order of stay to be granted or denied, that once it is granted, then we start arguing the application for the order of release. Is that what he was suggesting? My lord, good thing he agreed that it's a fantastic decision when it comes to, I don't recall very well the words he used, but he said it's a superb, fantastic one when it comes to bail anchored on special circumstances where there is an order of stay of the proceedings. And indeed, it's a locus classicus. And finally, my lord, this issue of advanced age, 69, 63, 66. My lord, that ground alone, it's a standalone ground. If my lord court is satisfied, and indeed it's not in dispute, that one is 69, the other is 66, it's not in dispute, it has not been rebutted. That is a substantive ground, a standalone ground for it is on bail. Surely, if you prove that one, you may not even prove others. That would be sufficient. Advanced age. So, and there is a reason to that, my lord. How do you have a statesman like Dr. Besigye, who is now almost 70 years, on remand? My lord, I want to conclude this point. He made some reference to the Bible. Mr. Beautiful made reference to the Bible. Life expectancy, according to the Bible, is 70 years. So how do you put a man who has almost hit his life expectancy biblically under incarceration for a period of over 1 year? Wouldn't even be here pleading, my lord. It would be automatic. We appreciate the pressure the state is facing, the prosecution they are facing from some extraneous forces to have this matter handled one way or the other. But, my lord, justice rushed is justice crushed. So we shall not, my lord, countenance a situation, and we implore this court not to do so, where we shall have a mere trial which is not in tandem with the provisions of Article 28, fair trial. So, my lord, I beg to end there.
Court, which is the Court of Appeal, and for bail. We have argued both applications. Although the judge has been giving us rulings on the spot, today and characteristically he reserved it for tomorrow. There's been talk about who is responsible for the delay, and as counsel in the matter, I would say squarely, the prosecution. You will remember even in January, after the Supreme Court ruled that the court-martial of civilians, military trial of civilians was as unconstitutional, it took them a long time to transfer the files. And at that time, they were holding our clients illegally, without warrants, because warrants had expired on the 3rd of February. They did not take them to the court until March. And in the Nakawa court, it took them another almost 3 months, March, April, May, up to the end of May, for the committal. So the delay squarely is on the prosecution. The delay by the court in giving bail, even after our clients finished 180 days, that cannot be blamed on us. Our clients are not holding themselves in prison. They are being held by the Republic of Uganda. So let the prosecution pull up its socks and let the courts of law do justice to the case.
Olwaleero bazze ku wajunga application yaffe erimu ebintu bibiri. Ekisooka nga tusaba kooti eno eyimirize proceedings ezibadde zigenda maaso oba omusango guno okuguwulira okutuusa nga constitutional petition gye twateekayo number 31 ey'omwaka guno ng'ewuliddwa ng'era esaliddwa. Ekyokubiri nga tusaba Dr. Besigye and Obedi Lutale baweebwe bail. Ebintu bibiri. Naye muwulidde state kyeyogedde ng'abaddamu omwami Yoweri Museveni kyeyayogedde ng'ayita Mutayebwa nti ffe twagala bulemesa proceedings, twagala musango guwulirwe, tuli wano okulemesa court. Baagala kutwala Dr. Besigye ne Obedi Lutale mu marathon trial etagoberera mateeka, etali etali ya bwenkanya, bafune conviction oba okubasalira omusango babatwale kalabba. Bekye baagala speed papa bakubirire. Ate nga petition yaffe eri mu constitutional court egamba nti enkwata Baguma gyakuttemu omusango guno emenya ssemateeka n'amateeka gonna agafuga emisango egifaanananga guno gwe balimu. N'olw'ensonga eyo nga ffe tugamba mwami Baguma alina okuvaamu. Kakati twebuuza kiki ennyo ekyo ekibapapya, lwaki Baguma alina okugenda mu maaso speed papa akubirire batuukirize kiri mwami Yoweri Museveni ne mutabani we Muhoozi kye baagamba Dr. Besigye baagala batwalinga mangu. In fact baali bagambye na 9 June nti bajja batwala kalabba. Kakati kye tuliko olwaleero tusabye Baguma ayimirize omusango, n'ekyokubiri ate Dr. Kizza Besigye okutuusa nga kooti etaputa ssemateeka emaliriza. Ekitunyamizaamu nti ruling tagituwadde olwaleero. Bulijjo bwe tusaba buli lunaku lw'oteekamu application ruling ng'agiweerawo, naye olwaleero agambye ajja gituwanca. Ate akomyeko ekyo n'agamba ya email. Tulina okwenyamira n'okuvuunya mu mutima. Buli we bagamba ruling nti egenda kujja ku email, rulings situfunangayo ruling ng'ejjidde ku email ng'eri positive. Katusabe ku luno kibe kyanjawulo.